Welcome to my channel Lectures on Law on CPC. This is the seventh lecture. In the last lecture, we had discussed about the frame of the suit. Instead of frame of the suit, rather the heading should have been relief to be claimed in the suit, because frame of the suit and the relief claimed in the suit are two different expressions. Relief claimed is that what we want from the court. हमें कोर्ट से क्या रिलीफ चाहिए, हमें क्या राहत चाहिए कोर्ट से, दैट इज द रिलीफ इन द सूट. एज फार एज द फ्रेम ऑफ द सूट इज कंसर्न, फ्रेम इज समथिंग डिफरेंट. फ्रेम ऑफ द सूट क्या होता है कि जैसे हमारे इनहेरिटेंस का है, ए डाइज, ही लीव्स बिहाइंड 3 चिल्ड्रन एंड देयर इज अ डिस्प्यूट बिटवीन 3 चिल्ड्रन. अब तीनों बच्चों में वो जो डिस्प्यूट होगा उसको डिसाइड करने के लिए डेक्लरेशन का दावा होगा, पोजीशन का दावा होगा या किसी और तरह का दावा होगा. इट डिपेंड्स अपॉन द नेचर ऑफ द फैक्ट्स एंड सर्कमस्टांसेस ऑफ द केस कि उसमें हमें किस टाइप का, किस फ्रेम ऑफ सूट में हमें वो रिलीफ लेना है. सो दैट इज एक्चुअली द फ्रेम ऑफ द सूट. बट however the legislature in its wisdom has said that it is the frame of the suit instead of relief in the suit. Now we have discussed about the parties to be implicated as a party, or on whose behalf the suit can be filed, or against whom the suit can be filed. And we have also discussed the place of suing, where the suit has to be filed, what is the territorial jurisdiction of the court is concerned. Now the question arises that we have decided it. Client आपके पास आ गया है, आके उसने आपको फैक्ट्स बता दिए हैं, आपने पार्टी सेलेक्ट कर ली है, आपने फ्रेम ऑफ द सूट और द रिलीफ टू बी क्लेम्ड इन द सूट डिसाइड कर लिया है. नाउ द क्वेश्चन अराइजेस दैट क्या आप कॉम्पिटेंट हो दावा करने के लिए, और यू विल हैव टू एंगेज एन एडवोकेट or a recognized agent, or if you are living at some other place and the territorial jurisdiction is concerned is at a different place, then how the suit has to be filed and who can pursue the suit. Now the third order deals with the recognized agents and the pleaders. So the legislature in its wisdom has framed this code of civil procedure in such a manner in which the suit progresses, meaning thereby that we have to select the parties, we have to select the relief, then we have to select that who is the person who is competent to file. Now earlier there was a Pleaders Act under which every legal practitioner was enrolled, because Advocates Act was not in vogue, was not on the statute book at that time. So pleaders had all the duties to plead the case of a party before the court. Now in olden times, the pleadings were not written by the advocates but were being drafted by the deed writers. They used to write the plaint as suggested or as directed by the pleader, and the pleader used to plead the case before the court. Now the word pleader has been abrogated and the Pleaders Act has been replaced by the Advocates Act passed by the legislature, in which the word pleader has been replaced by the word advocate. Certain rights of the advocates are there, certain duties are of the advocates are there, and if any advocate does any act which is against the etiquettes, against the professional ethics, then he can be hauled up and he can be held liable for the misconduct and can be punished accordingly. There are various rights and duties. Senior advocates are being designated under the Advocates Act, which are appointed by the High Court or the Supreme Court of India on certain criteria. Now, as far as the recognized agent is concerned, now this word is of wide connotation. ये जो recognized agent है, this is directly connected with the Indian Contract Act. In Indian Contract Act, we can appoint an agent. Those agents so appointed by us, they act on our behalf. They are our representative. Any act done by the agent is binding on the principal. That is known as vicarious liability. Now, as far as the advocate is concerned, his rights are different, and for engaging an advocate, a power of attorney has to be signed, and that power of attorney has to be filed in the court. And then, if the advocate is to be replaced by another advocate, then the consent of the court is required. And if the court permits the advocate to withdraw from the case, only then the second advocate can come. That is also known as no objection certificate to be obtained from the first advocate. No reasons are to be assigned, but the first advocate can withhold the consent for valid reasons, and those reasons depend upon the facts and circumstances of the case, and they are separately taken into consideration by the court while allowing the advocate to withdraw from the case. Now, under Order 3, certain rights have been given to the advocate that he can act on certain matters. There are a number of acts on which the advocate can independently act on behalf of the client. And all those acts which are being undertaken by the advocate are binding on the agent. Now, as far as the recognized agent is concerned, now here we have to give a pause. Now, there are different type of recognized agents. As we had discussed while discussing Order 1, that there has to be a power of attorney. I can appoint my relative, my brother, my sister, my son, any other person, my friend, as a power of attorney. And that power of attorney gives certain powers to that person under the Power of Attorneys Act. And the power of attorney so appointed can act on my behalf in all the court proceedings. Now, those rights which are given by me to the power of attorney are binding on me. I cannot resile from the same. So, power of attorney has to be got registered under the Registration Act, and it has to be on a particular stamp paper as is prevalent in various states for different denominations. The amount of the stamp paper may be different for different states. So that has to be got registered, and then on the basis of that power of attorney so registered, the attorney can act on behalf of the principal. Now, with that power of attorney, these are of two types. One is general power of attorney, and the second is special power of attorney. Now, as far as the general power of attorney is concerned, all the powers are given generally to the power of attorney holder to act on behalf of the person concerned. Now, in that power of attorney, a provision can be made in which it can be said that a special power of attorney can be appointed by the general power of attorney holder, and that special power of attorney has to be in paramateria with the powers given under the general power of attorney. So, anything done by the general power of attorney or the special power of attorney holder who has been appointed under the powers given under the general power of attorney has to act in that framework. He cannot get out of those framework. And the attorney is liable for any acts of omission and commission. If he commits some negligence, then he can be hauled up. And all the provisions of the Indian Contract Act regarding the agency are applicable to the agent also. So we have to study the Indian Contract Act in that context also. Now, second is only I can give a special power to a special person or to any person to act on my behalf for doing a particular act on my behalf. Suppose I want to file a particular case, then I can authorize my special power of attorney to act on my behalf, and for that purposes I will give him a special power of attorney, and that special power of attorney is binding for that particular act. He cannot act generally. So that is a special act. Now comes the definition of the recognized agent. Now if the company is there, company by means of a resolution authorizes a person to act on behalf of the company, then that person is competent to act on behalf of the company. He can receive the summons, he can receive the communication on behalf of the principal company, and any service of summons or applications served by the court are binding on that person. He cannot escape the liability. He cannot say no, that I will not accept the summons so issued to me by the court. And any service made on the recognized agent, that is the special power of attorney holder, or a person authorized by the company under the Companies Act, he is authorized to, and that is a deemed valid service. So if after receipt of service of summons he does not appear in the court and absents from the court, then the legal consequences of his abstinence from the court will follow. मतलब ये कहने का कि अगर recognized एजेंट के ऊपर भी सर्विस हो गई है किसी भी प्रोसेस की, किसी भी एप्लीकेशन की, किसी भी समन्स की, तो then those are binding on that person. So recognized agent means that suppose a company is having branch offices throughout India or at 20 places in India. So any branch officer, branch manager or branch officer who is controlling the affairs of the company is known as the recognized agent, and he is competent to receive the summons, and any summons so served on that person will be deemed to be a service to the company. Suppose partnership deed is there, and a partnership deed, the partners appoint a certain person to accept the summons or to act on behalf of the firm, then any service of summons on that partner is valid and competent and will be deemed to be a valid service under the law. So it is not there that he cannot get the service summoned on that aspect. So these are the things which are to be taken care of, and the person so appointed as a recognized agent or a power of attorney holder by means of a power of attorney, then service of summons or service of any process on that person is a competent service. Now the last but not the least, memo of appearance is filed, and that is only for the purposes of one appearance. Suppose your power of attorney holder or the person, your client, is residing at a different place and he does not have the time to send the regular power of attorney to you to appear in the court, then certainly in those circumstances he can ask you to appear in the court on his behalf by filing a memo of appearance. Now, in that memo of appearance, one has to write the name of the person who has engaged you, the purpose, and all other particulars, service, address, and etc. etc. All that is provided under the provisions of the Code of Civil Procedure. So, with the provisions of Order 3 CPC, we come to know that who are competent to file the suit on behalf of the person as a power of attorney holder or as an advocate, and what are the rights and liabilities of the particular act. So in the next lecture, the real journey of filing of the suit will start, and shortly I'll be addressing in my next lecture about the same. In the meantime, you can subscribe to my channel and get the knowledge of the CPC in simple, lucid, and meaningful terms. Thanking you. Your